also have the state of Nebraska's Solicitor General, Jim Campbell. Jim was the attorney who led up the argument on behalf of the state this morning. So I think we probably got everyone on. So what I'll do is just give 2 minutes of background on the case. There's a lot of discussion about student loan discharge that was the discharge that was made by the Department of Education. And I think it's really important to understand what this case is about. And it's not whether or not a discharge is a good idea, whether the case ultimately, or whether the discharge was appropriately balanced or unfair. It's not really a policy question. It's really a question of the Constitution and separation of powers, because this question is whether or not Congress is under our Constitution, Congress is the entity that's given the authority to legislate, and that includes the power of the purse, the ability to spend, or in this case, discharge almost $500 billion federal funds without a vote of Congress. And so in this case, the Department of Education, the secretary, in their action would wipe out well over $500 million ultimately of student loans without a vote of Congress. And so the state of Nebraska, along with 5 other states, filed a lawsuit on really asserting those constitutional rights. And we won at the 8th Circuit Court of Appeals. That student loan program has been stayed, and then we had the argument here this morning. The argument went for about, we were in court almost 4 hours. There were actually 2 cases. We went first. There was another case from the 5th Circuit from 2 individual borrowers that also went in front of the United States Supreme Court. We went first. And primarily, there were 2 questions in front of the court. The first is whether or not this was, this action by the secretary was authorized by any statute. And the federal government has pointed to the HEROES Act. The HEROES Act is an early 2009-11 era, War on Terror era, piece of legislation that allows, in certain circumstances, the secretary to waive or modify certain requirements of student loans. And that was a piece of legislation that was there, that was never, doesn't reference discharge, doesn't mention cancellation. It's a piece of legislation that the individuals who passed it said it had nothing to do with student discharge or student cancellation. In fact, we know Congress since then has tried on multiple occasions, including over the last year or two, with the Biden administration, to pass legislation to discharge loans, and those efforts have not passed. And so our argument from the Supreme Court was that there was no statutory authorization and that Congress didn't permit the secretary from doing this really massive action without a vote of Congress. On that point, there were quite a few, I think, skeptical questions from the court, from the chief to Justice Barrett and a number of justices in between, really pushing on that point and questioning whether or not the HEROES Act actually authorized what happened. The second argument is a threshold argument as to whether the state of Nebraska has standing, which is sort of it's a legal concept that says whether or to what degree an individual or an entity in this case can actually file a lawsuit. Not everyone can file any lawsuit at any time, and there's a lot of legal doctrines on that. Nebraska put forward, along with the other states, including Missouri, put forward a number of different arguments on standing. The one that the court spent the most time was on the entity called Mohila, which is in Missouri, which is a public corporation, and it was the state's position that that corporation, which is created by the state, has a board of directors appointed by the governor, is subject to FOIA laws and public records requests. That's a public instrumentality for which the state of Missouri has the ability to file a lawsuit. And so we argued standing. There were a number of questions on that standing point. We feel comfortable and confident going into the argument with our cases and our argument. We feel good coming out of it as well. So with that, I'm happy to answer any questions. There are some in the chat box for anyone who joined late. Please use the chat box. So I'm going to read this question from Chris Dunker. You said this wasn't a question about student loan discharge, but instead about the federal government taking action. Excuse me, I'm on an iPad trying to scroll. Not given to it by Congress. That said, there were nearly 150,000 Nebraskans who applied for and were accepted into the discharge program. What would you say to those individuals who are hoping to get some debt relief through this program? Thanks for the question, Chris. I'd say the same thing to them as I would to the individuals who paid off their student loans early. I'd say the same thing to those individuals as I would to people who never had the opportunity, didn't go to college, and are using their taxpayer dollars to fund someone else's discharge. This isn't about the underlying policy. And as a former legislator, when I had that on, when I was wearing that hat, I understood that the legislative branch is the branch where those policies are discussed. This is about a fundamental question. Is it Congress or is it the administration that has the ability to spend $500 billion and to legislate these discharges? And if the Supreme Court finds that this action is lawful, I think that the repercussions are significant because it's the breathtaking grasp of executive power. And you can bet if this action is successful that Republican administrations down the road, Democratic administrations down the road will seize that opportunity and look for obscure legal hooks that really have nothing to do with the question before them to do really massive changes that whether you like that policy or not, there's an opportunity to be heard in Congress, and that Congress has not saw fit to actually pass that bill. So it actually goes beyond the individual policy, and it's all about, does Congress have the right to legislate or does the executive? I think our system of government is founded on the idea that we have separate branches of government with separate powers, and we have to respect that. The Constitution means anything. Okay, thanks, Chris. Quick sum up. We're going to send around a separate press release with some comments regarding that argument. I don't want to recap that now because it took me a few minutes to go through. I want to be respectful of everyone's time. And I apologize. I'm trying to scroll with my thumb on the questions here. Justice Barrett, this from Chris Dunker. Justice Barrett asked pointedly several times today about who wasn't in the room. Why not let Mohila or Nelnet or other loan servicers file the lawsuit? It's a great question, Chris, and Justice Barrett asked a number of really strong questions on the standing question with Mohila. Mohila has the ability to sue or be sued. And by the way, it only takes one of the states to have standing in order to be able to bring the merits argument, to reach the merits. Mohila has the ability to sue or be sued, but it's also a public instrumentality of the state. And so it's just as if the state of Nebraska were to sue in different contexts on behalf of agencies and the investment council, or something where you really is part of the state government. And so in this case, Mohila could have sued. They didn't sue, but they didn't sue because the state of Missouri filed lawsuits. They didn't need to sue. And ultimately, I think that was the crux of our argument. And I think Justice Barrett's questions I thought were very probing, and I thought were great questions. And I thought our Solicitor General, General Campbell's answers were very strong. We feel good that at the end of the day, if this is a state entity, it's state control, that state assets, that the state can sue on its behalf. Okay, do we have any other questions? From Brian has a question. Can you speak on the emergency nature of the action? That's what the administration points to as a permission slip. Well, that's a great question. So the specific language in the HEROES Act gives a limited set of powers under a limited set of circumstances to the administration, and specifically allows the administration or any administration to be able to waive or modify certain types of provisions that don't make anyone, to ensure that someone's not made worse off, but it also, amongst the conditions, is a requirement that it has to happen during a national emergency. And here, the federal government has declared COVID, the pandemic, as a national emergency. There wasn't a lot of questions during the argument here. I mean, we have pointed out that on the one hand, the federal government, the Biden administration, has declared the pandemic over. I know a lot of people think that the pandemic feels like it's over. The actual national emergency is going to be canceled, I believe, in May. Certainly, we have suggested in other contexts that feels pretextual. It's kind of hard to say on the one hand to the public that it's over, but on the other hand, tell the court that it justifies widespread and sweeping application of this particular statute. And so there wasn't really the focus of a lot of the questions at the court today. In fact, I don't recall much, as there were some allusions to the pandemic, but really not a focus on that particular piece of it. I will say, though, that if the court does uphold this particular action, I think it does drastically widen the scope of executive power. And Justice Kavanaugh talked about this a little bit. Whenever you have a national emergency, whether it's the Korean War, I think he referenced during the argument, certainly we've seen in our nation's history instances in which the federal government, the president has tried to seize far more power than maybe is justified. You see that in many of those instances, when there's an emergency, the federal government, the executive, tends to naturally try to seize more power. It's really the Supreme Court is one of the most important checks on those attempts. And you've seen it, by the way, with this administration. They've done it with the eviction moratorium, CMS or one of the vaccine mandates where they tried to use the pandemic as a lever to be able to grab more power for the executive. In those cases, the Supreme Court pushed back. We're hopeful that the Supreme Court does that as well here. We have a question from KLKN about how long can we expect the arguments to last. Well, the arguments today between the two cases went about 4 hours. I think our argument was 2 to 2.5. They don't let you have phones or there is a clock, but it's sort of it's not right in front of you. You don't have your phone. So I think my best guess is a little over 2 hours. In terms of the opinions, themselves, we would expect no later than late June, maybe the first part of July. Historically, that's when the term would end. We're hopeful with this. There are some historical examples where the courts acted more quickly. We're hopeful that would be the case here, but certainly the court didn't give any indication on when an order might come down, and there's nothing that would necessarily cause them to bring an order earlier. Another question from Bill, just to clarify, would your argument be that if this debt relief was approved by Congress, the debt relief action would be legal? The crux of our argument is that this was not approved by, there is not an explicit statute discharging this debt. Congress would know how to discharge the debt. They didn't decide to discharge the debt. That ultimately the questions balancing the fiscal and economic impact of this major political question are best left to in the Constitution leads to Congress. And so I think in that instance, certainly I don't, depending on how Congress would do it, and I hate to go too far into a hypothetical and just say, well, whatever Congress decides, it would be constitutional. But certainly at the end of the day, Congress has the authority to do these kinds of things. And had they decided to spend $500 billion and there was a federal grant for it, I don't, the constitutional issue that we're presenting wouldn't exist, certainly. And by the way, the Congress has done things through the CARES Act or through ARPA, through, you say, for instance, the PPP loans. Those are instances where Congress does know how to discharge loans, and those were constitutionally permissible. Chris Dunker says, what would be the impact to Nebraska specifically if SCOTUS rules this program is constitutional? Well, certainly we have some stand, Chris, to the extent that your question relates to standing, we did have some standing arguments regarding impact of discharge of these loans on our state budget. That really wasn't the focus of a lot of our arguments here, but I think Nebraska's concern really is one that I think all of our sister states, whether they joined or not, I think is goes to really the core of our Constitution, which is separation of powers. And so Nebraskans, Iowans, Missourians, anyone who joined in our lawsuit, but also Californians and those from New York or Florida, those who didn't, will be impacted. Whether they're impacted by this case directly is one question, but they will absolutely be impacted down the road if this is ruled lawful, because some future administration would use this as this opportunity to expand their powers in ways that they might not like down the road. Okay, I don't see any other questions. Are there any other questions? Oh, I'm sorry, I missed one. Would you consider yourself optimistic or some other term after today's argument? That's a great question. I mean, first I would say, I've listened to enough argument. Reading tea leaves of the U.S. Supreme Court or frankly any other court is not something, I'm not in a prediction game. I will say though, going into the argument, we were very well prepared. Jim Campbell was very well prepared, did an outstanding job, had answers to the questions that were provided to him. Coming in, we felt we had a really good argument on the merits and on standing. I think coming out of it, there were no arguments on either of those two that really put us coming out of it, a lot of pause as to whether we would be something we didn't consider, something that we think really undermines the thrust of our argument. So what the Supreme Court ultimately will do, they could surprise us, but certainly going in, we felt good, and coming out, we felt just as good, if not better. Is there any more? Okay, I don't think I see any more questions. Well, I really appreciate everyone joining us. It's a big day. It's an important case. It's an important case for our country. It's an important case for the Constitution. It's an important case for the state of Nebraska. And I think our team did an outstanding job. It was a team effort, and they really represented the state well in the arguments in front of the U.S. Supreme Court. So thank you all so much.